record and then start the live stream.
Before we do that, oh.
Thank you very much.
Yes.
Okay, now 1 second. I will wait for the live stream to load, and then I will let you know when it's recording. Okay, we are now live and on the record.
Thank you. Our next case is 2020 P 1267, Department of Children and Family versus Mother and Another. This case, as you know, is impounded, so please do not use any names. With that, Mr. Ferguson.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Hugh Ferguson, and I'm representing the appellant Mother. This is a child welfare case that's not unlike so many other child welfare cases. We have a mother who's got unacknowledged psychiatric difficulties and has been diagnosed with multiple sclerosis since the age of 21. She will be 36 next month and has been on Social Security disability since she was 21. We have the Department of Children and Families, which knew at least since Mother was the age of 16 that she had a disability and needed accommodations. These are never provided in spite of that knowledge. During the case we have, during the trial, we have a social worker who testified that Mother never claimed a disability. And I would argue to the court, that's not her responsibility to claim she has a disability. The case record is clear that it's there. The social worker also testified she, quote, never saw it in the record and was also unaware of any disability protocol within the department. The court ordered a court clinic parenting evaluation, which the evaluator arbitrarily changed to a psychiatric evaluation, which she did because she got a limited response from the Lynn DCF office, and she bumped up against her own vacation. However, and very importantly, she stated that Mother was responsive to her requests for information. And although she did acknowledge Mother's report of multiple sclerosis, it was not considered in the report, nor was it considered as part of the evaluation. The report was submitted to the court on October 19th, 2016. This evaluator never observed a parent-child evaluation and diagnosed this mom with bipolar disorder. We also have a therapist who, after several sessions working with Mother, diagnosed her with mild cognitive disorder and mild anxiety. And in spite of the ADA's requirement to evaluate persons with disabilities on an individualized basis, as well as the adoption of Lenore, which states at a minimum, the department must accommodate the, quote, special needs of biological parents who are handicapped or disabled, and the adoption of Ilona, where a parent, as here, has cognitive limitations that affect the receipt of services. The department has a duty to make reasonable efforts to preserve the natural family, including a requirement DCF provided services to accommodate the special needs. No such evaluation was ever done, nor were any specific services offered which related to any accommodations Mother might need. I think it's also important to note that the department has been involved with this mother for virtually her entire life. From
Counsel, how do you get over the issue of waiver?
Waiver of what, Your Honor?
Waiver of this argument that the cases say that the issue of reasonable efforts has to be raised through a motion or a request for a hearing or something.
If I'm not mistaken, Your Honor, it was raised at trial. I would have to get back to you on that, but I'm pretty sure it was raised at trial by counsel for Mother.
Well, is it that too late by the time of trial? I mean, the argument is that DCF wasn't providing adequate services during the commencement of the case, right?
During the pendency of the case, I believe that's right, Your Honor. Yes, it was.
And there was no motion or anything filed. Is that correct?
I did not see one in the record, Your Honor, no.
Okay.
It's important to note also that at the birth of mother's first children, the twins were only one survived. A CNP was filed it was not filed then, it was filed later. But mother and father worked collaboratively with services, and the children were returned shortly after a year during which that case was open. She married father in 2012. They had the child who is the subject of this appeal. Pardon me. As I said earlier, the evaluation was turned in on October 19th, yet 2 days before that evaluation was due, the department changed the child's goal to adoption, and not unsurprisingly, everything went downhill from there forward until father returned to the Massachusetts area after working out of state for approximately 2 years. Towards the end of the case and shortly before trial, mother and father were compliant with services. They were visiting. The social worker remarked in the court report of May 2nd and 3rd, 2019, that for the period of October 1st, 2018 through May of 19, which was the last report before trial, mother was noted to be consistent and came to visits prepared with snacks, activities, games, and puzzles. Trial commenced on July 5th, 2019. So during the 13 months leading right up to trial, mother continued to make significant strides. These were not recognized by either the department nor by the judge at the trial court. In fact, they were ignored by the judge. And I have to say that since trial, mother has experienced some significant declining health as a consequence of the multiple sclerosis. She is aware her child is being well cared for and is comfortable with that. But this is not an unfit mother. This is a mother with a major medical disorder who did not receive the accommodations that she was entitled to. The child's permanency can be assured with a guardianship, which does not require a termination. Mother supports father in his appeal, but she would ask this court to remand this to the trial court for a finding of permanent custody to the department without a termination of parental rights. Thank you.
Thank you, Mr. Ferguson.
Thank you, Your Honor.
Ms. Chevrolet.
Good afternoon, Your Honors. May it please the court. My name is Dana Schoenberg, and I represent the father. Who objects, he would like this court to vacate actually the decree that terminated his parental rights and denied him visitation with his son. He's challenging, or we're challenging many of the court's findings as they pertain to 4 different issues here: the domestic violence, his lack of insight or alleged lack of insight into mother's mental health issues, which would prevent him from providing the child the minimally acceptable level of care. And then also the finding under Chapter 210, Section 3, the sole finding that the judge found pertained to him in support of the termination, which was his willful failure to visit. Now, all of these.
I don't read the judge's decision that way. That the judge found that factor was the one that was applicable only to father and not to mother. It wasn't saying that that's the only factor applicable to father.
Oh, yes. Oh, so that is fair. I did interpret that to mean that, because where she indicated this factor is not applicable, this factor is not applicable, then she specifically stated the ones that were applicable to mother pertaining to the mental health. Then she specifically stated the one that was pertained to father. That's why I interpreted that out of all of the 14 factors, this was the one in particular that pertained to father, which was the
in the listing of factors, the other ones say either this factor is not applicable or this factor is applicable. And so I take that where she says this factor is applicable, she means as to both parents.
Fair. Sure. But if it is that one factor, I could understand how Your Honor would interpret it that way. But the willful failure in that factor that pertains to father, it's based on stale evidence. She repeatedly refers to his lack of involvement. Excuse me, I got a little hoarse. His lack of involvement in the first 2 years of the litigation, but sort of fails, I feel, to flesh out the reasoning for his lack of involvement, which was the fact that he was traveling to support his family. So he was not readily available to attend visits with the child in person, although he had been calling into those visits up until January of 2017, at which point the department told him he was not able to do that. And then as to the visits in that, that were pertain to that section, that subsection 10, he did visit. He did pick up engagement in the case with the department, meeting their service plan, meeting the expectations of his then service plan, and then also visiting the child consistently for a year leading up to trial. So for that particular factor to apply only to father, we posit that that's based on stale information and should not be given deference. As to his lack of insight into mother's mental health, the department, it was clear that having worked with mother in the 14 years that she had been involved with the department, they didn't understand the details they didn't understand fully what mother needed. So I feel like we feel that it's unreasonable for the judge to criticize father for not fully understanding her diagnosis. Even though he didn't fully understand it, perhaps we could make a reasonable inference that factually he was incorrect or he's inaccurate. He did do what he needed to do for the year leading up to trial after her discharge from Worcester. He did what he needed to do to maintain her stability in the home. And that is supported by not only the record, but by the court's findings for interpretation of the record. She found that they had been managing their marriage. She found that there had been no similarly violent incidents, the one that occurred back in December 2017 that triggered her admission to Worcester Recovery Center. There had been no, the record reflects that there had been no police responses to the home. Now, the court did use mother's behavior in court to indicate that the problems that mother was having prior to that had not been fully resolved, but that's our position is that is impermissible speculation. That there could be, it's a little bit of a stretch, although there's recent case law that says that a court can look at a parent's conduct in court when there's no record evidence to indicate that that was the case at home. That finding should not be given deference. And his lack of insight, being unable to fully articulate the details of whether it was her multiple sclerosis, the lesions that were causing the other symptoms, or whether there were other symptoms. I think the general consensus is that we all understood, and father understood, that there was this multiple sclerosis, but then also there were other things. But she was being treated for that, and the treatment that she got, the treatment schedule that she received from Worcester was effective. He was relieved at that, and in his role as her PCA, once he returned to Massachusetts, he was able to manage her successfully in the household. Meanwhile, the visits with the children were going well. Father and the child were obviously bonded, physically affectionate towards each other, despite any short absence that father had in person with the child. As far as service, I see my time is winding down, but as far as service plan compliance goes, the court faulted father for not engaging in a batterer's intervention course, which under Yale was really unnecessary. She also found that there was no evidence to support that father was ever violent towards the mother. The mother was always mostly the aggressor. So for her to fault him for not taking the batterer's intervention course was unreasonable, and he shouldn't have been penalized for that. Given mother's position that she is happy with the placement of the children, father still would like this court to remand the case, or at least vacate the case or vacate the termination decree and the determination of unfitness to return the child to him, and if not, remand it so that we can talk about the visitation. The courts.
Thank you.
Sure.
Mr. Salcedo.
May it please the court, Richard Salcedo for the Department of Children and Families. I will be splitting my time. I'm not sure if Attorney Cohen has joined us, but
Yes. No. He's here.
Splitting my time with counsel for the child, 10 minutes for the department, 5 minutes for Attorney Cohen. The department is asking this court to affirm the trial court's decision finding mother and father currently unfit parent this child and terminating their parental rights. Careful review of the trial court's 145 findings of fact show that close attention was paid to the evidence, and those findings taken together clearly and convincingly support the trial court's conclusions. With respect to parents' compliance with services in the year preceding trial, the court did not ignore those efforts. Specifically, the court found at finding 92 that mother had begun seeing a therapist weekly and a psychiatrist monthly after she was released from psychiatric hospitalization in 2018, and that she had been appropriate during meetings with the department. The court also found at finding 106 that father had begun to engage in services, including therapy, and that he had attended all meetings with the department and that visits were appropriate. The court also found, however, that mother's recent compliance was inconsistent, that she discontinued treatment with the psychiatrist and that she refused to engage in other services recommended by the department and by her treatment providers, including anger management, parenting class, and DMH services. Those findings are at 86 and 87. Although she was diagnosed with schizophrenia and bipolar disorder in her teen years and had been hospitalized for psychiatric reasons on multiple occasions and has struggled with her mental health issues for most of her adult life, mother testified that she does not believe she has mental health issues and that she does not need medication for those issues. She denied needing to be treated by a psychiatrist and further indicated that she had no intention of working with one in the future. The court also specifically found that father only partially complied with his service plan. While he did engage in therapy as required by the plan, he also denied that he needed any mental health treatment. And by the time of trial, he was not consistently attending his appointments. While father testified that he attended parenting classes, he failed to verify his compliance with the services. Father also testified that he engaged in anger management education, but the court found that he could not articulate what he had learned. Also, despite well-documented history of domestic violence in this case, much of it based on father's own reporting, the court found that both parents deny that domestic violence is even an issue, and both refuse to engage in related services to address it. Further, despite these recent efforts, positive efforts that parents made, the court was entitled to weigh additional evidence in this case, including couples' prior long history of non-compliance with services. Prior to this year before trial and parents' partial compliance, court specifically found that father had failed to utilize services made available to him after the child was removed in 2015, and he stopped all communication with the department and was whereabouts unknown for approximately 2 years, from 2016 to 2018. And during that time, he indicated that he did not want to be involved with his son in his son's case, and that's at finding 103. And he had no contact and no visits, and there was no evidence he made efforts to contact the department to inquire about his child's well-being. Court also found that during the 8 months that she was hospitalized in 2018, mother declined to engage with the department and rejected department efforts to schedule visits with her child. The court also considered the serious history, lengthy history of domestic violence in this case, which began in 2012, the year after the child was born. Many of those serious acts of physical violence perpetrated by mother, often in the children's presence, led to a series of 51A reports, police responses to the house, and resulted in mother being arrested and on several occasions hospitalized. And a number of these serious incidents are detailed in the court's finding at finding number 12. The record also indicates that this violent behavior, this pattern of behavior, which occurred while the child was in their care, continued after he was removed. In 2017, mother assaulted a DCF worker during a meeting at the DCF office. And in December of 2017, she attacked father, threatened him with an axe in the home, smashed items, which again resulted in an arrest, and with mother being psychiatrically hospitalized. The court further found that when mother was hospitalized at that time in 2018, that she assaulted and threatened to kill staff at the hospital, and that she had to be physically and chemically restrained on multiple occasions. Further, despite claims that she had regulated her medication regimen and her condition was improving, evidence indicates that mother continued to struggle to manage her volatile behavior. And specifically, the court found at finding 26 that proceedings had to be suspended on several occasions due to mother's violent outbursts, which included yelling at and using profanities towards a DCF worker who was testifying and a court officer. Court also found at finding 96 that mother was disruptive in another care and protection involving another one of her children in 2019, and that she had to be removed from the courtroom in handcuffs. Court specifically concluded that although she had been partially compliant that previous year, that there does not appear to be much improvement made in her condition, and further that her current mental stability and temperament still pose a great safety risk to the subject child. Unless the court has any questions, I would rest or rely on my brief and urge this court to affirm the trial court's decision.
Seeing none, thank you very much. Mr. Cohen.
Good afternoon, Justin Cohen for the child. The child has lived with the paternal aunt since 2019, and he's happy to live with her. He's outgoing and eager to please. The paternal aunt is the assistant superintendent of a school system. In 2017, this child was diagnosed with attention deficit hyperactivity disorder, ADHD, and post-traumatic stress disorder, PTSD. He was also delayed in his reading and writing. The paternal aunt knows exactly where to get services for him. She got a tutor for him. He takes some medication for his ADHD. And he also goes to some after-school programs. The paternal aunt has gone to meetings about getting services for this child, and she wants to adopt him. By contrast, when the child lived with the parents, the child used to have tremors before he ate because of the domestic violence that he witnessed. For example, he witnessed mother chasing father with 2 knives and punching father in the face. And mother never complied with their service plan, and she insisted on not doing any domestic violence training. She also had a number of visits that were terrible, and she was also very difficult with DCF personnel. She claimed that there was no domestic violence and that it was not a problem with the child. And she had mental health issues dating back from when she was a teenager. Father also never complied with his service plan. Father also had his own mental health issues. When he was traveling and DCF tried to call him, he said, quote unquote, they were listening to his conversation. And he called this case garbage at the trial. Father also denied that there was any domestic violence issue because he called mother harmless. And he also denied that it posed any problem with the child, that it had any effect on the child. Father argued at trial that he would do something with this child, like he would take some action to get this child back, although he didn't do it. In his brief, he claimed that he would never leave mother. So it would be traumatic for the child to go back to a situation with the domestic violence that permeated this case. So just to recap, the child is very happy being at the paternal aunt's, and she wants to adopt him. I see that my time is almost up, so if there are no further questions, I'll rest my brief.
Seeing none, thank you, Mr. Cohen. Thank you all.
Thank you.